there has been a, over the last few years since the pandemic, the trademark office has been a little more forgiving about not using your trademark for a certain amount of time. Like, for instance, some of our service industry clients weren't able to provide services during the pandemic, so they weren't able to use their trademarks. The USPTO actually created a form where you can tell them why you're not using your trademark. The rule of thumb, as far as the USPTO is concerned, if you haven't used it for 3 or more years, you've abandoned it. If you stop using it and you document an intent to resume use, you can rebut that presumption as well. One last orientation thing that I'm going to do for everybody is talk a little bit about the Trademark Trial and Appeal Board. So it's an administrative body. It does a very specific things in terms of trademark challenges. It hears appeals from the USPTO. So Kim is going to talk about office actions and appealing office actions. So that would be heard there. Oppositions to registration. So I'll be talking about that. And cancellation, Sarah is going to be talking about cancellation proceedings. That's all they do. What they don't do is injunctions. They don't do infringement issues. They don't do unfair competition. They don't do awards of damages or attorney's fees. All they care about is who's entitled to a trademark. With that orientation and background, I'm going to turn it over to Sarah. Oh, I'm sorry, to Kim.
Thanks, Bev. So let's start off with ex parte proceedings, and this is kind of going to go in order as to involvement, because ex parte means any single person can bring an action against any application or registration seeking to challenge said application or registration. So you can cancel a mark in part or in whole, and technically we can do that for applications through letters of protest, or we can do that for registrations through expungement or through reexamination. And both of these are new under the Trademark Modernization Act. This went into effect December 18th, 2020. And when this first went into effect, the USPTO actually wanted to clear the register. And so they allowed marks that were over 10 years old to be challenged for 3 years. And then if you didn't get your challenge in after that, because there's a time frame that is narrowed for each of these particular ones, the examination and the expungement, then they're going to be registered for life and you missed your window. So there was an opportunity to clear out a mark that you just did not want, but if you missed the window, you missed the window. So the Trademark Modernization Act did amend the Trademark Act of 1946. So first, let's look at letters of protest. So why would you want to protest this way? Well, because you can stop an application from ever hitting a registration. So if you have information that something has been filed, you can immediately put together a letter of protest. And a letter of protest can be filed as soon as this application hits the docket, but it cannot be challenged after the 30-day time period for publication, which is the time for opposition normally when something is filed. So a letter of protest kind of gives you a jump on getting something in front of the USPTO as far as not being able to be registered, right? So technically what you're doing is you're going to submit objective evidence as grounds to refuse, and you're going to submit evidence that's appropriate for an ex parte proceeding, which means no one else is going to need to give the examiner any information. You have it all set up. And so appropriate grounds for filing a letter of protest. Very important to understand that it's going to go along the lines of office actions, which technically are going to be items like merely descriptive. Someone is trying to file a trademark that everyone is using in that particular industry. You're going to want to stop that because everyone's using it. If this person gets a registration on it, then everyone who's using it will have to stop. You don't want someone to trademark something that's generic already, and it's kind of the same lines as everyone using it. Inappropriate identification of the good or the service, because that means that that will be misinterpreted and it could cause other problems for other people using it. So we want to make sure the appropriate goods and services have been identified. If they are claiming priority to another application and it's incorrect, or it's going to stop somebody else from using something they've been using, you want to stop that application. The biggest one is likelihood of confusion. So likelihood of confusion, basically, if there's a registered mark or an application already on file that this mark is going to interfere with and cause confusion, it will be stopped, and it should be. Anything that's not in use in commerce, we don't want to say that it is and try to get it registered. And then anything that's in a litigation situation, so it's already up for an adversarial process, that definitely should not go through the registration process. And so as long as you keep in mind things along the lines of office actions, where it's going to be a situation where you can present objective grounds as to why it should not be registered, you can do that in a letter of protest. Excuse me. So again, remember, you only have up until the 30 days after it's been published for opposition to file a letter of protest. When you're filing a letter of protest, it's very important to understand what to include, because this is how your letter of protest will either succeed or fail. Inappropriate grounds, definitely you want to keep away from those when you're filing your letter of protest. So you don't want to create a situation where someone else would have to chime in on your particular filing. So keep away from common law prior use, applicant not being the owner, or any disagreements with an examiner. That's not going to get you very far. Matter of fact, your letter of protest will be thrown out. But you do want to put together your objective evidence very succinctly. You are allowed 10 pieces of particular backup evidence, but only 75 total pages. So do it that way you will, but you have to be very succinct and you have to be very organized. Each protested mark that you're protesting has to have its own letter of protest and its own backup. If you try to group them in one letter and put all the backup together because they're related, it's not going to be reviewed by the USPTO. Where to file your letter of protest? The USPTO does have a wizard for your letter of protest. So you would go into letters of protest, you would click into filing a letter of protest, and then you would submit your fee. And the fee for filing a letter of protest is $50. It is a TEAS form, so you would submit it through TEAS, and you would present your full investigation. And so when I say full investigation, you have to show everything that you've done to prove that there's no reason this should be this application should move forward based on your appropriate grounds, okay? And then the outcome, if you do put together a successful letter of protest, then you will get information that says that it was a successful submission, but that will be all you will get. You won't get any correspondence back and forth. Once you do that, then the USPTO will pick up and institute an investigation based on what you've submitted. If you submit letters of protest and it is incomplete, mostly because the organization of the evidence is not there, or the evidence that you submitted is not all relevant, then you will get a notice that your submission is incomplete, but it will not tell you why, because the office cannot help along these types of protests. You have to do it yourself. So you'll just know that it's incomplete. You won't know why. You will get the notice of non-compliance without any details. The USPTO does have 2 months to review anything that you submit. And if the USPTO picks up your letters of protest and moves forward with the investigation or not, it's completely up to the USPTO, and it is not reviewable. So if you disagree with the USPTO and you say that they should have picked it up as an investigation, most likely that's going to point to the package you submitted. So make sure your submission is complete when you put it together, because once the USPTO decides to not pick it up, it's not reviewable or appealable, it's final. Now, for ex parte challenges to registration, for expungement and reexamination, several things are similar, so we're going to kind of group these two together. But what's different is at what stage a registration can be challenged, and when you're going to file. So who can file is the same, how to file is the same, and what to include is the same. So For an expungement, eligible registrations are at least 3 years old, but not older than 10 years. So if anything is beyond 10 years, it's safe from expungement. If anything is younger than 3 years, it's safe from expungement. Reexamination is based on a date. So for instance, when you are presenting an application, you can have, like Bev already talked about, an intent to use application, or you can have an application where your trademark is already in use. If your trademark is already in use, then your relevant date is the date that you file your application. It must be your registration must be in use by that date, or else someone can put you up on a reexamination. If you filed an application that says, I promise to use it within a certain amount of time, the date that you allege use, or that you promise to allege use, that is your relevant date. So if you do not have your mark in use in commerce, when you register your, when your mark is registered, you can be in danger for reexamination. Expungement is if you've never used your mark. So I think Bev has already mentioned this, but use your mark. Using it is actually the basis of trademark law. So using your mark before you register it is actually a great idea. So definitely put it in use. And once you get a registration, continue to use your mark. Don't not use your mark. And if you do decide to not use your mark, please let your attorney know so that we can do the right thing for you and adjust your filings. Also, to move along, who can file? So again, for both expungement and reexamination, anyone can file these particular filings. It can be a person, an entity, or an attorney. And in some instances, attorneys do get pulled to do these particular challenges because they are very particular, one. Two, it can be picked up by a competitor that doesn't want to be known. So in a lot of instances, attorneys will do these for their clients, but you will not be allowed to abuse the system. So if the director of the USPTO gets any whiff that this may be something abusive on the registrant, they will command or demand to know who is behind the filing. So you are not anonymous. So just be careful with that. How to file. You must provide a verified statement to the USPTO, and the verified statement has to include the registration, your contact information, what goods and services you have in question, details of how you believe the mark has not been registered or has not been used. That's a difficult thing to assert, but for folks who do this for a living, they know exactly how to show that you're not using your mark. So please, again, use your mark. But also, there's ways for us to go back in time to find out whether or not you've been using your mark. And if you decide to try to cure this problem, as soon as you get a notice from USPTO, it's not going to cure your problem. The only way to fix this is to head this off and use your mark. When you're presenting your petitions, it's very important that you present the full file, just like when you do an ex parte proceeding for letters of protest, because any missing document means the whole thing is thrown out. You will not know what caused the problem. You'll just get a notice of deficiency and you'll have to figure it out. In this instance, you do get 30 days to cure your submission. So if for some reason you missed something or you didn't do the index, which has to be extremely particular, your indexed 10 pieces of evidence that you're going to submit, make sure that the index is separate from the evidence, make sure the index is titled with each piece of evidence that you are presenting, make sure the evidence is related to the class or good that is in question, and make sure that that particular layout of evidence matches the index, because what the examiner is going to do is lay them side by side, look at your index and look at your evidence. If it's off, they can decide not to look at it. So just make sure everything's in pristine shape and it all matches. Your job as a petitioner is to create a prima facie case. You have to let the examiner know that there's enough evidence to say, hey, they never used this mark, or they didn't use it by the date they said they would. If you do that, then it will be a proceeding that you'll get notice of. The registrant will get notice that they are involved with an expungement or a reexamination, and then it moves forward. If you cannot cure your submission, you can't fix it in 30 days and it's deficient, then the director won't pick it up. And that's a final decision, non-reviewable. You can't appeal that. Now, you can present enough information and you can pique the examiner, the director's interest And you may not be able to create a prima facie case, but you may have created enough for the director to say there's something here, and the director can actually pick it up and continue on with an examination, but you will not get any information on that because it wouldn't be based completely on your case and you haven't hit all of the criteria, so you wouldn't get notification. You would just have to watch the board for that, which we all know is our trademark document retrieval system. Which you should be watching anyway, because that's where all the information happens, and whether or not you get notice of it is no excuse. So lastly, most petitions fail for lack of organization and lack of an index. So make sure you organize your information. So just, I've said it before, but I'm just gonna reiterate it here. Make sure you document any searches that you're doing to prove anything, to back up any of your letters of protest, your expungement, or your reexamination. Negative results is excellent. So you have a search and nothing pops up, print that screen, include it. You need to make sure that you're putting in as much evidence as possible. Make sure your evidence is relevant. Do not do a data dump. They're not going to look at it. The USPTO is busy. That's what they tell us, at least. So you must make sure that this is all relevant information and it's organized. And if you use any official trademark documents, make sure you include those official trademark documents. Don't do lists, screenshots of lists of information. Make sure you pull out the actual document and include it in the record. And now I'm going to throw it to Ms. Sarah to talk about cease and desist letters.
Thank you, Kim. So I actually love a good cease and desist letter. It's one of my favorite things to draft as part of being a lawyer and a litigator. It can be really interesting. And why do we send a cease and desist letter? You'll find that it's often the first step in many different kinds of disputes, including trademark disputes, because the law and the courts and the judges are not going to be supportive of a system where it's a gotcha, where you drag someone into court without explaining to them why they've infringed something or why they've done something wrong. The goal is to actually lay it out to them very clearly, and a good way to do that is in a cease and desist letter. Send that out to them, set out, attaching evidence, what it is you say they've done, what it is you say they're infringing, what it is you say they're breaching. And you might find that I've had plenty of cases settled purely from sending a cease and desist letter. So it actually is to your benefit to educate the person you're sending it to on what it is you're saying they're doing that's wrong. You'll also find that, a cease and desist letter will be one of the first things you attach to your complaint, should they continue to infringe or to breach. And judges like to see that on there, like to see that you've taken various steps to try and resolve it pre-litigation, and you'll find it'll be beneficial for you and be looked on more favorably. What do cease and desist letters look like? Generally, there really isn't any rhyme nor particular template for a cease and desist letter. I say generally because this is the law, so of course we work within the exceptions within the law, and I'll tell you more about that later. But it really, as long as you're including who you are, what the issues are, and attaching relevant evidence, citing to particularly relevant law if needed, that's pretty much what you need to do with that. And you can work through with your attorney as to what it is your goal here, what you want to try and reach, and that should all be taken into account when they're drafting up a cease and desist letter for you. What do you do if you're on the receiving end of a cease and desist letter? Well, the first thing is don't panic. If there's any clients tuned in here, then I would say contact your attorneys. Goal and Christy Taglia has excellent attorneys who can assist you with all of your legal needs should you get a cease and desist letter. Read it carefully. If you are infringing something, then maybe this is an early opportunity to solve it, resolve it, get an early settlement without being dragged into expensive, onerous, ongoing litigation. So don't panic, talk to your lawyers, digest what it's actually saying. If you do have defenses to it, then you're going to want to, just like the cease and desist letter, you're going to want to do a fulsome response that explains to the other side exactly why you aren't infringing, breaching, or doing any of the allegations that are being made in that cease and desist letter. More specific to trademark cases, be wary of trademark trolls. You'll find, particularly more and more commonly these days, there will be trademark trolls or individuals who will send out a wide net claiming that you're infringing their intellectual property or infringing their trademark. A lot of the times people are not, but they will often go to small businesses, individuals, and it's kind of a scare tactic. It's a bit of a shakedown just to try and get, that they might settle with you for $500, but say they've sent out, 2,000 letters. They're trying to get their $500 from 2,000 different individuals. And the USPTO undertook a study recently on this issue and used data gathered from attorneys, professors, businesses of all sizes. And the USPTO's findings were that this is an increasing tactic. It's an aggressive tactic that involves using cease and desist letters to really threaten. And they're finding that it is scaring a lot of smaller businesses and individuals away from continuing to use a name in fear of retaliation by a larger, trademark owner or someone who claims they're a trademark owner when they're not necessarily that. And, our firm in recent days has certainly had an uptick in calls from people getting these aggressive trademark infringement letters. I think Bev has had some recently.
Yeah, I actually got something that was a different take on the trademark troll. Instead of saying, "Oh, you're infringing on my client's trademark," a lot of people were contacting us because they got an email saying someone's infringing on your trademark, and you need to hire us to protect you. When I looked into it further, actually, there was no infringement in every instance that I looked into. There's no infringement. And it turns out that this company or organization that was sending out the email was actually a company out of California that was trying to sell trademark watch services for a yearly fee. And so it actually was a scare tactic to get people to hire them and pay them money to watch their trademarks for them. And just to let you know, if you are a trademark client of GCT and you're in our system has an automatic watch service for new applications and activity at the USPTO level that's just automatic and it's complimentary. So, paying these guys $500, $1,000 a year to do what you get complimentary from us was I had very grateful clients saying, "Oh, phew, I don't need that." So that was just a new take on it. You just have to be careful when you get this stuff.
Yeah, more and more it seems to be a cash grab than anything else. And, I said at the beginning here that generally there's no rhyme nor particular method for a cease and desist letter. Well, I'm about to give you a couple of different examples and an exception to that. So this is relative to a declaratory judgment action, and declaratory judgments are often requested by parties that receive cease and desist letters so that they may continue to use their trademark without fear of infringement and not have to worry about rebranding or registering and protecting an entirely new mark. The essential requirements for a declaratory judgment action are that there's a plaintiff with a tangible legal tangible interests, a defendant that has an opposing interest, and an actual controversy between the parties concerning those interests. So you need that controversy. There's a 2019 case, Wine Store Holdings versus Justin Vineyards and Winery, that involved a North Carolina wine retailer versus a California-based wine retailer. Wine Store had applied for the mark Overbrook, while Justin Vineyards owned the mark Overlook. So Overbrook versus Overlook. Justin sent a cease and desist letter to Wine Store saying, frankly, things you would generally kind of expect to see in a cease and desist letter. Things like, our client believes that this trademark is too similar to its Overlook trademark and its use could be interpreted as intending to trade off the goodwill of our client's distinctive trademarks, creating a likelihood of confusion. Wine Store filed an action in court seeking a declaratory judgment that the use of its Overbrook mark does not violate any federal or common law or purported trademark rights of Justin. Justin then filed an opposition to Wine Store's application for that Overbrook mark the following day. Justin subsequently filed a motion to dismiss Wine Store's declaratory judgment action on the basis that Wine Store had not satisfied the case or controversy element required for a declaratory judgment. And the court actually held that sending a cease and desist letter to an adverse party was not enough to create the required case or controversy if the letter does not contain specific language and firm demands, even if it is followed up with a notice, filing a notice of opposition with the US State Trademark Office. The defendant argued that the demand letter's language still fails to reflect a definitive dispute, meaning that there is not a clear case or controversy between the parties. It's not entirely clear from the ruling what exactly would have been necessary to include in the cease and desist letter to get past this issue for Weinstall, but comments on in the judgment suggest that basically it wasn't aggressive enough. The court noted that Weinstall never filed or threatened to file a lawsuit alleging infringement, and that they expressed their preference to settle matters amicably where possible, while asking the plaintiff to contact them at their earliest convenience. I actually find this a bit troubling because in cease and desist letters, you do want to walk a line of, you are infringing, we can potentially bring a hammer down here and enforce against you. But you want to settle the matter for your client as quickly as possible. So to say we want to settle matters amicably, we want to try and reach an agreement here, those are things that I would routinely put into cease and desist letters. But it's something to keep in mind here in terms of trying to get a declaratory judgment on that trademark infringement allegation. And now we can go to a fun one, if we just flip over here. So this is an interesting one. And if you're a GCT attorney signed in here, you may have heard of this one before, because it's kind of a favorite of the IP team here. In August 2017, Chicago-based Emporium Arcade Bar opened a pop-up location called the Upside Down, which was designed to look like the sets from Stranger Things series. The only problem was that they didn't actually get permission from Netflix, and Netflix in-house lawyers sent this cease and desist letter, which was an even-tempered but effective approach. You can see it up on the screen, but bear with me while I read it out for you. Danny and Doug, my walkie-talkie is busted, so I had to write this note instead. I heard you launched a Stranger Things pop-up bar in your Logan Square location. Look, I don't want you to think I'm a total wasteoid, and I love how much you guys love the show. Just wait until you see season 2. But unless I'm living in the Upside Down, I don't think we did a deal with you for this pop-up. You're obviously creative types, so I'm sure you can appreciate that it's important to us to have a say in how our fans encounter the worlds we build. We're not going to go full Dr. Brenner on you, but we ask that you please, 1, not extend the pop-up beyond its 6-week run ending in September, and 2, reach out to us for permission if you plan to do something like this again. Let me know as soon as possible that you agree to these requests. We love our fans more than anything, but you should know that the Demi Gorgon is not always as forgiving. So please don't make us call your mum. The bar owners cooperated and closed down in September as planned, and no further action was taken. I think Netflix here were very clever in the way they went about this. They got a lot of good publicity from it. And if they had have taken a harder stance, I think they might have risked alienating a pretty large fan base. So this is just an example of how you can get creative with it. You can have some fun with it, and pick the right tone for what you're going to be dealing with and what your client wants, frankly, just to get to the outcome your client wants. So I think we're going over now to Kim for office actions.
Office actions. Okay. So office actions, kind of like cease and desist letters. When you get one, don't panic. Office actions are more and more prevalent these days. So it's very rare that you get your trademark registration without having office action. So whenever you file an application for a registration, this is going to pop up for you. If you own a trademark, practice trademark law, or deal with trademarks in any way, you know what office actions are, but just in case you don't, it's an official letter sent from the USPTO by the person that's looking at your application, which is the examining attorney, and it can list legal problems with your application, or it can list particular requirements with your application that you missed. And it'll identify those issues either about the mark that you're using, the form and content of your application, or both. And it's discovered right away. You get the office action as your very first communication from your examining attorney. And then all problems that are asserted in your office action must be cleared in order for your application to move on to the next step. There are several types of office actions. There are two basic types, which are your non-final office actions and your final office actions. But then within office actions in general, there are examiner's amendments, priority actions, suspension letters, inquiries, notices of incomplete responses. Those don't normally require a whole lot of feedback with the examining attorney. A lot of times you're able to get rid of whatever the issues are pretty quickly. And the requirements that come under your office action will usually be issues with how you presented your information, the mark, what you identified as the goods or services, things like that that needs to be corrected. And then a refusal is a little bit more substantive. Refusals usually tend to be around likelihood of confusion, merely descriptive. You don't have proper priorities, stuff like that, a little bit deeper. Whenever you get an office action, you must read it because there are so many types. Some of them, like I've already said, are so quick and you just maybe need to make a phone call or you just need to email your examining attorney. The deeper refusals will require a written response and usually quite a bit of backup. And that's a major legal issue with your application. But whenever you get an office action, my rule of thumb is always call your examiner. You need to clarify exactly what they want, and you need to make sure you give them exactly what they're expecting, and a phone call is the best way to do that. And in a lot of instances for my clients, I'm able to resolve a very dense office action because I'm calling the examining attorney and we're walking through the application and the submission. The submission process is as streamlined as the USPTO can get it, but it's not without its mistakes or its like quirks and bumps and certain things that happen. So just call the examiner first. That's the best thing to do, and then respond accordingly. When you get an office action, you have 3 months to respond. You can extend your response time 3 months for $125. If your office action is non-final, that means that you have an opportunity to respond, get it back to the examiner. If you fixed the requirement or the reason for refusal, then the examiner will let you know and they will give you a notice of allowance to go to the, not a notice of allowance. They will resolve your refusal or your requirement and then proceed you on to the next step. If you have a final office action, that is a second time around refusal for the first office action that came through that was non-final, which means you did not resolve those first issues and you have to revisit them again. Now, a final office action does get you to a couple of options, but something very important to note about a final office action. And let me catch up here on the screen. So a final office action is any office action you receive does not change the amount of time that you have to respond to any office actions, okay? So anytime you receive an office action, the timing is still running no matter what interaction is going on between you, your client, or you and the attorney that's examining it at the USPTO. So be mindful of your deadlines because if you miss a deadline, your application abandons. There's ways to fix that, but try to avoid it as much as possible. Avoiding abandonment is about almost 70% of trademark law. It really is. So it's very important to mind your the timing for response. Your final office action, you have two choices. You can ask to reconsider, so you can tell the same examiner, hey, we've gone over this 2 times, but how about one more time and I'm going to present more evidence, and please bring new evidence because the evidence you've already presented, don't try to explain it another way, they're not taking it. So you have to find something new to present. Requesting for reconsideration does not toll your time to respond. So in the advent that you're not able to overcome with a request for reconsideration, you need to file an appeal, depending on what it is. So normally if it's substantive, you will file an appeal. If it's a requirement, you can file a petition, and we'll talk about that in a minute. So anytime you file, you receive a final office action on a substantive issue, you can file the request for reconsideration, but definitely file an appeal because you're gonna save your application from abandoning, having that appeal in place, and the appeal just waits for the examiner to decide on a request for reconsideration whether or not you've overcome the issues at hand. If you receive a final office action, but there are no substantive issues, but there are requirements that are outstanding, you can file the request for reconsideration, you can file the appeal of the TTAP, but you can also file a petition. And filing your petition is a little bit different than filing an appeal. We'll talk about that in a minute. Remember, if you're filing a request for reconsideration because you just swear up and down, this third time is the charm, in case it is not, make sure you file an appeal at the same time to keep your process going forward. If your application abandons, it is not the end of the world. You can revive an abandoned application for 2 months post abandonment. However, it is another cog in the wheel. It is a process that takes you away from getting this registration through, and it costs money, as does everything with the USPTO. So just try to avoid it. So when you file an appeal or when you file a petition, generally filing an appeal is pretty straightforward. There's a complete section in the USPTO system for the TTAB. And so you'll be filing your appeal with the Trademark Trial and Appeal Board. And technically what you're doing is you're going to let them know that you disagree with the examiner and you disagree with them on these issues and these classes. So basically whatever the examining attorney has identified as an issue, you would identify that in your appeal and you would pay a fee per class. So everything that you are disputing with your examining attorney requires a fee to be paid. If you do not pay the adequate fee, then you leave the USPTO to either throw out your appeal or decide for you. Don't do that. Don't do that because they're not going to get it right. First of all, you have all the details. So make sure that your fees line up with all the classes that are involved and make sure everything is clear for the TTAB. If you fail to assert a class or if you fail to pay the money, then those things can either be completely thrown out and you'll have to redo a whole nother appeal, or if it abandons, then you have to revive. It's too much. So just make sure you file all the classes that are in question and all the fees to support those classes. You can file an appeal in the same time that you are given an office action response time. So if that makes sense, if you have 3 months to respond, then you have 3 months to appeal. Okay, so any time to appeal is going to be 1-for-1 with an office action. When you decide to move forward with your appeal because your request for reconsideration was not accepted, and you now have to move into the TTAB proceeding, you do owe the TTAB an appellant's brief, excuse me, and that's due within 60 days of filing of the appeal or when the appeal is actually moving forward. So if your appeal is suspended upon determination of the final determination from the examining attorney on your request for reconsideration, then as soon as it moves forward, that's the date that starts your 60 days to move in order to present your appellant's brief. And all of the brief requirements are found in section 2.126. I'm not gonna go through them, we don't have time, but no new or additional evidence can be submitted because remember, you have said that this examiner has it wrong. You have to present everything that you presented to the examiner so that the TTAB, the examining attorney, so that the TTAB can then review that. If during the appeal, the TTAB sees, oh, there's more grounds we should have said that this was not going to be registrable, which happens all the time, then it actually comes out of the TTAB process and goes back to the examining attorney. So again, being buttoned up with all of these propositions that you bring to the USPTO is so important because they're all related. And so if it goes back to your examining attorney, they're going to put it back through the process. The process would start over with your same, your 3 months would start over. But again, you would be in a situation where you're dealing with the same examining attorney. So you're not going to escape that examining attorney. Oral arguments for TTAB are very rare. TTAB is pretty much a paper system, so you don't really have to worry about that, but you can ask for it on a special case. TTAB decisions, once they are in and decided, are pretty final. They don't say that because you can reopen them for particular reasons, but not a lot of success in doing so. When you file a petition really quickly, you need to make sure it's for appropriate subject matter that the director can review. You need to make sure that you have your statement of facts, everything, all the points to review and the relief requested plus your required fee. And this works very well for requirements because it just falls into line with what the director is already looking at. Your supportive brief, make sure you stick that in there as well as the answer to the office action. Don't think your petition or your appeal is going to get you away from answering your office action, because that's kind of the first thing you have to do in order to appeal or file a petition. So you must answer your office actions. It must be filed within 2 months of the issue date of the action or date of receipt of filing from which the relief is requested. So as soon as you hear that your examining attorney is just not buying your story, then you want to file your petition straight away. Don't usually get an oral hearing here either unless you request it under special circumstances. Filing a petition, just like filing an appeal, does not stop or toll your deadline. So please stay very diligent on your deadlines. And if the director denies your petition, you can ask for a request for reconsideration, but you only have 2 months to do so. And if for some reason the director denies your petition and you miss it, you have 6 months to say, oh, I missed it, give a good reason, and then you may be able to revive it as a matter of cost. But definitely you want to be mindful of your deadlines and be mindful of your submissions so that the first time around is the best time around. And now Bev is going to talk about oppositions.
Thanks, Kim. So oppositions happen after the trademark has gone through the process with the examining attorney. So the examining attorney has looked at everything, you've responded to the office action, and the examining attorney says, I buy everything you're telling me, I'm going to approve this for publication. And this goes both for use-based applications and intent to use applications as well. So once you pass that threshold, the examining attorney schedules it for publication. And every Tuesday, the USPTO publishes the Gazette. That is what it's called. It used to be like a phone book in the ancient times. It used to be like this big phone book of trademarks. Now it's all online. And these are all the trademarks that have been approved for publication. Once it's published, anybody who feels that the registration of the mark will interfere with their rights can file an opposition. And what is the universe of oppositions? Well, it's pretty narrow. The ones I've seen most, of course, are a likelihood of confusion. In other words, this trademark, if it is registered, is going to cause confusion with my trademark. And there are several factors that are looked at. We haven't discussed this too deeply, but in terms of a likelihood of confusion, there are either the DuPont factors or the Polaroid factors. They're pretty much the same, but 3 percolate to the top. The first is that the marks look the same or similar. So if they're the same or similar mark, that weighs in favor of a likelihood of confusion. The second factor is, are the goods the same, or goods and services the same or related? In other words, is it downloadable software and versus non-downloadable software? Customers would be confused. They're really not going to discern the difference. So that's the second factor that we look at. The third factor that I'm seeing more and more is the similarity of trade channels. And it's a little misdescriptive as to what that actually means. Usually what you're focusing on there is, who is your customer base? Because most goods and services now are deliverable through the internet. So, it's not like you need, it's not like, you're just delivering it to the town next door. So that's not really the trade channel we're talking about. What we're talking about is, are we going to be marketing to the same customers? Are you marketing your non-downloadable software with a similar name to the same customers that I'm going to be marketing my downloadable software to? So those are the 3 major factors that we look at. It'll weigh either for or against a likelihood of confusion. There are a smattering of other things that I've seen, such as it's descriptive, but if it's made it through the examining attorney's process, that's probably already been taken care of. A geographical indication that may be a misdirection could also be a problem. For instance, Idaho potatoes they're grown in Idaho, but if somebody in, say, Michigan is going to grow potatoes and call them Idaho potatoes, that would be a problem for Idaho. Another one that I've seen lately is, it doesn't function as a trademark. It's just ornamentation. It's not really a trademark. And then another one that I just recently had, it was actually a cancellation proceeding, but the issue was similar. It was a term that was an industry term. Everybody in the industry had known about this term, had been using this term for almost 100 years. And in fact, the person who was seeking registration on this had written a little booklet about how it's been around for over 100 years. So we brought an opposition, I can't actually, that was a cancellation proceeding, but we were successful because we were able to show that he knew that this wasn't something that he wasn't supposed to be trying to corner the market on. And then one that I see usually when there's been a dispute between two parties already, and that is a bad faith filing. So the two situations I see these come up with are either a disgruntled employee or former business associates who've broken apart. And there's usually an unregistered trademark, in other words, just a common law trademark. And the disgruntled employee or the disgruntled former partner files a registration, files an application to register that trademark that's been used by the other guy and not them. And that is a basis for an opposition proceeding. The time frame for bringing an opposition is within the 30-day publication period. You can extend it for an additional 30 days or for 60 days by paying a fee. And that is a draconian deadline. You either make that deadline or you miss it. The proceedings themselves, they're very similar to what Kim was talking about, and they're also very similar to litigation in federal court. You have a notice of opposition, which is your complaint, and an answer. You do discovery, you do written discovery, request to produce, interrogatories, request to admit, and just get depositions. You take oral testimony, all of that. You can have dispositive motions like summary judgment. And then here's where it's all unique. Just like with the opposition proceedings in the TTAB, it's all done on paper. There's oral hearings are very rare. Sarah's probably going to talk about a situation where it was actually would have been important to have an oral hearing, but they're very rare. And you have instead of going into a courtroom and having a jury and a judge, it's a trial phase. So the opposer has 30 days to submit all their evidence. They submit what's called a notice of a reliance, which lists out all of the evidence that they're relying on and their legal briefs. Then the applicant has 30 days to a 30-day trial phase to do the same and rebut whatever the opposer's been saying. And then the opposer gets another bite at the apple, a rebuttal period. Once all that's in, the TTAB makes the decision. There is some, I think the decisions are running like 18 months to 2 years from final submission. It takes a while, so don't expect a, easy peasy, just, right now decision on these things. There are post-trial proceedings are very rare, but they do happen. And if you don't like the outcome, you can appeal it. Now, an appeal from an opposition can go one of two ways. You can appeal to the district court or that has jurisdiction over the parties. So in this case, the district court, which is usually a trial court, sits as an appellate court. Or you can appeal to the Federal Circuit Court of Appeals. And this is a special circuit court of appeals that just hears intellectual property cases. The majority of the cases that they hear are patent cases, but they do take on trademark cases. And I've seen a rogue copyright case here and there over time, but that's your appeal options. Okay, over to Sarah for cancellation proceedings.
All right, thank you, Bev. So cancellation proceedings, honestly, not that different to opposition TTAB proceedings, but I'll highlight some of that for you. So what is it? It's an opportunity to attack and ultimately cancel another party's trademark rights. And it's different from an opposition proceeding because it happens after a party or an individual their trademark has already been registered with the relevant trademark office. And you as an interested party can then petition for the cancellation or invalidation of that existing registered trademark. And people who can bring this, it can be a competitor or it can be a member of the public. And I'll be talking about a sort of public interest case here shortly. Basis for cancellation can include non-use of the mark, abandonment. You've heard a fair bit about abandonment today from Kim. Fraud in the application process, genericness, is it a generic, and Bev highlighted some of that stuff at the beginning here. And there are some other factors that can render the trademark invalid, including under like a public policy kind of basis. And cancellation proceedings, you're seeking to remove the registered trademark from the official registry. As Bev said previously, there are no damages here. So, you know, this is different from a lawsuit or an arbitration, because you really are looking for that one thing and that one thing only, cancellation of a registered trademark. You need to file a petition, which is going to outline your interest in the mark and why the mark should be cancelled, which is the basis that we discussed just before, non-use, abandonment, et cetera, unlike the ex parte proceedings that Kim highlighted for you, the owner of the mark, if you filed for a cancellation of the TTAB, the current owner of the registered mark will get notified and then will have an opportunity to respond. So it is an adversarial proceeding. Similar to oppositions and lawsuits and arbitrations, there's going to be various stages, which include the submission of evidence and depositions, things like that. Also, like opposition proceedings, they are mostly done on the papers. You will have depositions, but the actual argument and what goes on in front of the court is generally all on, or the TTAB is generally all on the papers. But again, I'm going to be talking about a bit of an exception to that here, which clicks the next one. Specifically, I'm talking about the case of Harjo and Pro Football, and this case really highlights a couple of key points, which is the timing of when you bring these kinds of proceedings and also how that evidence is presented. So this was a decision of the TTAB to cancel 6 federal trademark registrations, which involved a professional football team, as they were then known, the Washington Redskins, because the TTAB found that the marks may disparage Native Americans or could bring them into contempt or disrepute. It was appealed by Pro Football to the United States District Court in DC. Interestingly, the underlying TTAB proceedings involved expert evidence from linguistics experts, and that evidence was they were deposed, and there was deposition evidence used as part of the briefs and filings to argue it, where the TTAB ultimately determined that those 6 marks should be cancelled. The appeals court, however, found that the defendants had substantially delayed in bringing their challenge to the marks. In the case of the first trademark, the defendants had waited over 25 years to bring the case. And they also found, importantly, that the defendants had had notice of the marks and that Pro Football suffered prejudice because of that. The court also noted that the TTAB heard no live testimony and that the testimony cited in its opinion merely came from deposition transcripts, which, as we've noted, is the common way, far and away the most common way that stuff gets presented at the TTAB in these opposition and cancellation proceedings. Ultimately, the appeals court determined that the TTAB's finding of disparagement was not supported by substantial evidence and reversed it. They also found a secondary basis that it should be reversed because the doctrine of laches precludes consideration of the case. Laches, I'm sure most of you know what that is, but that's the delay thing. If you find you have a claim or a challenge, you've got to bring it timely, and the courts are going to look, poorly on it if you wait sort of 25 years. Of course, since then, happily, I would say, the Washington franchise took the name of the Commanders in 2022 after 2 years as the Washington football team, and no longer refer to themselves in the way that they formerly did. So, you need to be careful, and you certainly have to be timely in bringing cancellation proceedings. And while generally you present stuff on the papers, there may be a reason, and you work through that with your lawyers, for why you are going to want oral evidence at times. And I think back to you, Beth.
Okay, so here, so that the substantive portion of our presentation, but we also wanted to just give you an idea of what we need, what we need from you if your trademark is being challenged, or if you want to challenge somebody else's trademark. This is a way for you to help us help you. In my mind, the first thing is, don't destroy anything, even if it's not very favorable to you. Preserve everything, because destroying even any type of evidence can jeopardize your entire case. So preserve everything. Don't, like with emails, don't forward emails to us. Copy the emails and attach them in email to us so that we have a good copy of it. That's one of my pet peeves, actually, is people just forward me all these emails. It's like, that's not helpful.
I second on that.
Yeah. Write a narrative of what's going on. Do it contemporaneously at the beginning, because as I said, when we're talking about a TTAB appeal could take 2-3 years. And 3 years from now, memories fade. You may not remember everything, but it helps us and it helps you if you write everything down. And it helps us evaluate your situation. Another thing, and it's really important, we know a lot, but we may not know your industry. So don't be afraid to educate us about your industry, because that can really help us in determining whether you can challenge a trademark or whether somebody else is properly challenging your trademark. So those are my little bugaboos that I like to tell clients about. Anybody else?
Yeah, so I'll just add to that. If you're a client and you're coming to see a lawyer, tell your lawyer what it is you want to achieve, because there are, in the way the system is here, the adversarial precedential system that we have, there are numerous ways that we can get you to a certain result. We can get you a variety of results. It's your job to tell us what it is you actually want, and then it's our job to provide you with the options and the risks and benefits of those options. And you'll find that some people go to lawyers or want outcomes that aren't necessarily the most obvious one. Spell it out for us, frankly, and keep repeating it, because that is going to be one of the most important things. Litigation, legal advice, lawyers, we're all very expensive. And if you don't want to spend all that money and not get to the result that you ultimately wanted. And then just reiterating Bev's comments about preserving all of the information, all of the evidence, all of the documentation. You absolutely need to do that. There are obligations. You can be sanctioned by the courts if you destroy anything. And it's important, if you do have something that's adverse, some evidence that's adverse to your case, provide it to us quickly. It's much easier for us to work a way around something and to outline your options for you if we know, all of the potentially problematic pieces of evidence or information that they're out there. And we can work out a way forward, or frankly, if it's adverse enough, we can tell you don't bother with the legal spend. This is why. So don't try and hide that. Don't try and bury that. Put that right at the forefront.
Yeah, and I'll just kind of add, I'm the broken record here because I've been talking about evidence and presenting your case as thoroughly as possible, but make sure that you organize anything that you're giving to your attorney, but don't take anything out or edit your record. Please give us everything, because we need to determine relevance. And it's very important that you let us do that. And so don't remove anything. Like Bev said, definitely don't destroy it, but don't self-edit. Just give us everything you have and we will put it together and put together the best case to go forward. Also, like I have already mentioned, use your marks. That is your best defense in any trademark challenge. Make sure you're using your mark and you're using it like you said you would. You can expand use, but definitely use it the way you said you're going to use it. And then monitor for infringement. That is so important, because you don't want a situation where someone is diluting your mark and you're not doing anything about it. Trademark ownership is also about protecting your mark, and protecting your mark is keeping people from infringing it and making sure that if they do infringe it, that you put them on notice that they're infringing it. So definitely monitor the system once you have a trademark registration.
And just one last thing that wasn't covered. If you do have a registered trademark, be sure to mark your products with it, mark your logos with it. Put the circle R if you're using your trademark in commerce, even if you don't have a federally registered trademark. You can put a small TM, which means you're asserting your common law trademark rights. And the reason why marking your products and your websites is so important, or your clients' websites or your clients' products is so important is because when you go to calculate damages for a trademark infringement suit, if you're marking your products, you get to calculate damages from the date of constructive notice as opposed to actual notice if you're sending them a cease and desist letter. So, just make sure that your logos and your trademarks are properly marked, or your clients are as well. And with that, we'll open it up to any questions that anybody has.
AJ, somebody emailed me directly a question as to whether or not they could bring an infringement suit and a cancellation at the same time. And the answer is yes, you can.
Right.
Probably one that, in my experience, the district court usually steps back and says, let's see what happens in the TTAB before we make a decision. Although, and there's a tension in the federal courts because they got to move the cases along. So they want quick resolution. But if you're challenging the trademark already, they may ask you to suspend the TTAB proceeding and add a count to cancel the trademark within that proceeding. So it depends on which court you're in, what the judge likes, but yes, you can do them simultaneously.
So one of our attendees asks, if you respond to an office action before the 3-month expiration, does the time still toll while you're waiting on the examining attorney's response, or does it reset while you're waiting on the response? Does anybody want to take this?
Sure, I'll take that. No, nothing tolls that deadline. So you respond as quickly as possible and, that's a very good question, but no.
Now, this wasn't asked, but just for everybody who's here, can you request an extension to the response?
You can request an extension as long as you're not out of extension, so you only have 6 months total. You get 3 just based on the office action being issued. If you're gonna get close to that 3-month deadline, then you can ask for an extension for 3 more months, but you only have 6 months total.
And you have to pay a fee.
And you have to pay it, yes, everything requires a fee.
always
Gotta pay a fee, gotta pay a fee.
Yeah.
I think we're nearly at time. I don't know if we have time for one more.
I think, well, we started 5 minutes late, so if we have any more questions, we can certainly take them.
So could anyone here share their experiences or challenges faced during TTAB proceedings, particularly in an opposition or cancellation case?
Actually, the 2 biggest situations I've had are if the other side defaults and getting that default in front of the TTAB and getting them to move on the default. They normally will do that themselves because they'll see that an answer wasn't filed, but I've had situations where it's just languished and nothing's happened, and so we've had to prod them. And the other is just like in litigation, it's in the discovery. It's in discovery compliance. That is usually the biggest single problem. Issuing your interrogatories, noticing a deposition and crickets, nobody's responding and you need to try to enforce it. And that to me is like the biggest problem. And again, that to me is the biggest problem in litigation as well.
Oh, I could talk for 2 days straight about discovery non-compliance,
Yes.
frankly.
Yeah, one of the things too, you have to remember when you're dealing with the United States Patent and Trademark Office, I'll call them by their full name. Because when you are given a deadline, you are to adhere to it, but they, for some reason, can take quite a bit of time to get back to you. So never promise anything when you're dealing with them, because we can, as much as we try to establish trends or we try to forecast, it just depends. It just depends.
So I think we have one last question here, and then we can wrap things up. I'll direct this to Sarah. How do you approach the management of cease and desist letters in the context of trademark disputes? And are there any best practices or common pitfalls that you've encountered?
Common pitfalls would probably be less me sending out the cease and desist letters on behalf of a client, but it does go back to when clients get cease and desist letters and responding to it. And it is that, particularly in the trademark area, it's the trademark trolls, because I have had clients, and this really is unfortunate. You want to do a really, really strong response because so much of the time the people don't have it is just.
They're fishing,
They're fishing.
right?
And you have your poor client who, maybe is just a student. We've had, we've had all different kinds of clients and they're not big businesses. And if you have to engage in the litigation to even, get yourself dismissed out of it, it's going to be expensive. So basically in those ones, when I'm doing a response, I would not be taking a gentle response. I wouldn't be taking a funny response. I would be quite aggressive in a response like that to try and get them to leave my client alone so they don't have to incur, so many costs just to involve themselves in the litigation and get dismissed out of it.
Absolutely, yeah, and I know that Bev and I were talking about this at some point, but if you do respond substantively to a lot of these phishing type cease and desist letters, most often than not, the opposing party will completely leave you alone because they're just looking for a quick settlement. And if your client has representation, then the cost benefit for them to continue completely drops off a cliff. And a lot of times you'll never hear from them again. Bev, I don't know if you have anything to add there.
That's true. Usually I'll get, I'll respond in a very forceful response. And what I get back is, you have no idea what you're talking about. Your client is infringing, blah, blah, blah. And then I say, I've said all I'm going to say. And that's it. We're done. And then I'll get probably another email, but then I never hear from them again. Another thing that sometimes comes up with these cease and desist letters is that client tries to respond themselves. And you heard the groans.
Yeah.
The groans around us here. Don't try to do this at home. It is, there's an art to it. Evaluating the right tone, doing the right research on it, whatever. Don't try, if you get a cease and desist letter, no matter what you think it might cost, it's going to be more expensive if you try to do it yourself rather than having somebody who knows how to handle it for you.
Heartily second.
100%.
Yeah.
Well, I think that was very well said. And we greatly appreciate you joining us again. Please send an email to Taylor Saucier, tsaucier@gct.law. Please present your ARDC number and preferred email address, and you will receive your CLE certificate along with an evaluation form. Thank you all very much for attending.
One last thing, our last slide has our contact information for everybody. If you want to just hit it one more time. Didn't go? There we are. Okay, there, now you see what we all look like.
Yeah.
And here's our contact information. Feel free to call or contact any of us if you have a question. We're always happy to answer questions. Doesn't mean we're going to bill you, not always, but we're always happy to be a sounding board and to answer questions. So feel free to contact us if you need us.
Thank you.
Thank you.
Thank you.